Hi, it's Toronto immigration lawyer Max Chaudhary, and I wanted to discuss a common question that comes up with candidates who are considering filing an application for some kind of visa or permanent residence or any kind of privilege for entering Canada. And that is, what is a complex application? And that's an important question because complex applications can often benefit from professional advice and or representation by an immigration lawyer. So it's something to contemplate when you're considering some kind of entry into Canada through legal means. In a very general sense, there is a bigger legal footprint with more complex applications, and that requires more scrutiny. So I will give some examples. For example, if there is a history of address changes and or residence in different countries, that could add an element of more scrutiny for an officer, triggering the need for example, more police clearances depending on the amount of residency accumulated in differing countries. And similarly, if there is a history of many more experiences, such as work experience, that could trigger the requirement for more scrutiny from an officer and lead to the risk of more inaccuracies in terms of an application that is being disposed of. Similarly, more particularly with, for example, a spousal application or an application where a spousal or common law relationship is key or relevant to the disposition or success, is how many marriages and or divorces have there been, or common law relationships. This would require an officer to scrutinize the application in more detail and ensure that the candidate is qualifying for a visa or permit, especially if an element of success is a genuineness of the relationship. More obvious examples of complexity is if there's an issue of admissibility to Canada. Admissibility could relate to a criminal history or to an expensive medical condition. In some lesser or more differing circumstances, admissibility may relate to the visa history and or visa compliance in another country. Another aspect of admissibility relates to whether an individual had worked in a government position, and what was that position? Were they in the top 50% of a hierarchy, for example? And another more obvious situation is when there is a history of an application which was refused. This would, of necessity, force an officer to look at the history of the previous application, which survives in the form of what are known as GCMS notes, Global Case Management System notes. And this issue of what constitutes a complex application is not confined to the type of application. It could be a temporary application such as a work or study or visitor visa, or a permanent resident application. And so if you are contemplating filing an application for permanent residence or temporary residence or some kind of other privilege to enter or remain in Canada, you may wish to get professional legal advice. If need be, you can contact us at Chaudhary Law Office. Thank you.